Good evening to everyone. It was indeed my pleasure. Indeed, it's my pleasure to address particularly the audience from Kerala, facilitated through LJRF and the DLSA and many other interesting personalities. This particular webinar happened to be an outcome of my discussion with Assistant Professor Safi Mohan in GLC Trivandrum. I think a month back, I was there for some other personal visit. And he was very particular that the subject ADR has to be well taken, not only in the law schools, but across the professional arena, wherein we need to explore this opportunity, as rightly pointed out by the judge from Ernakulam about the ADR, whether it is going to be academic or whether it's going to be the practitioner's perspective. This is going to be a real welcome note for the parties, the disputants, the important stakeholders who has to be taken into consideration is the litigant. Whether the litigant is going to get his final outcome within a time with a reasonable cost at the maximum limited levels of appeals. All these are very important for a litigant. The litigant, when they go to the courts, as rightly pointed out by Professor Ma'am Sindhu, it was clear that the adversarial process leads the parties to just stretch their resources to the maximum, and ultimately at one point of time there will be a concept called docket explosion, and the courts would be in a dire situation not even to deal with the case within a reasonable time. That is a acceptable fact. It's overburdened with a lot of issues. There are multiple reasons. To supplement this is very important. We have to supplement this particular situation, what's happening in the courts, with the important component that is ADR. It might be alternative. That's what the earlier speakers were highlighting about ADR, alternative dispute resolution. But now, after the development from 1940 till recently 2021, we can see that the scope of ADR is now not alternative, it is appropriate dispute resolution. This dispute resolution is quite appropriate. Why? Because this has been accepted by the parties, this has been authorized by the law, and this has also been authenticated by the mechanism enforcement or execution. We have the acceptance of the party, no doubt. The parties are accepting for this. It is not we lawyers or the judiciary is facilitating this process straight away. There are some opportunities, but still the first step is being taken by the parties. They accept for it. Not only they are accepting, their acceptance is being authorized by law. The laws like Arbitration Conciliation Act 1996, the greatest amendment in CPC, that is Section 89, then the Legal Services Authority Act 1987. All these are quite interesting development. To add on, there are three more interesting legislation which also gives us the authentication, the authorization, like Companies Act. Many of you would have gone through the Companies Act 1956 those days. Now, it has been totally repealed in 2013. It has been enacted in a new shape. It is not only in new shape, it also facilitates an interesting component, mediation in it. Most of the corporate practitioners would be familiar with it, but for entrants to understand that the Section 442 of the Companies Act 2013 facilitates conciliation and mediation. It's very interesting. It doesn't conclude there. It later part, it moves to another legislation in the year 2015, that is Commercial Courts Act. Commercial Courts Act 2015 also facilitates pre-litigation mediation. Now it has become like a pre-mandatory mediation. Then 2019, the Consumer Protection Act, the original version of 1986, got repealed, and an amended version 2019, there also mediation was included. See the interesting fact, from 1940, the development in the arbitration legislation, And during the course of liberalization, globalization, we had a major change: corporate dispute, commercial dispute, consumer disputes, in addition to the existing mandate given under the Arbitration Act, all have been combinedly facilitated now to go to ADR. These alternative dispute resolution by way of authorization. The authorization is there in the law. No doubt we can try it. And interestingly, we happen to see the Apex Code dealing with mediation, whether regarding the Motor Vehicles Act or the very historical dispute, the Babar Masjid and the land dispute. This particular dispute also been facilitated by mediation historically for several years, which was in a situation not to come to a proper conclusion for a longer time, through mediation facilitated by three persons coming from different perspective, tried to facilitate, and that has led to a settlement. Not actually a mediated settlement, but still that settlement was recorded and ultimately judgment was delivered. Now it is solved. This historical events which is facilitating the dispute resolution, particularly outside the court, has to be seriously taken by all of us. That is the very interesting objective of Section 18(9). That is, Section 89 of CPC facilitates multiple ADR mechanism. That is the first legislation which brings all aspects of ADR, wherein we practitioners can try to explore. What are those? That particular section says that a judicial authority shall, or if he finds an element of settlement in that particular civil suit, he can refer the matter either to mediation, conciliation, judicial settlement, Lok Adalat, or even arbitration. 5 interesting ADR platforms have been legalized. Now comes the authentication. This legalization makes not only the process convenient, but the outcome also to be enforced. Very important. In India, we have to be very clear that the outcome has to be binding. It has to be accepted. It has to be executed. That has now been facilitated by Section 89. The only problem with Section 89 is that in subsequent cases, it was confirmed that arbitration cannot be referred directly by the judicial authority. It has to get the consent of the parties, then only it can be referred. Keeping apart arbitration for some moment, all other ADR mechanisms can now be facilitated by the court, not only afresh, it can be for pending suits. Here comes a very important thing for practitioners and law students to understand, that what is court annexed mediation. The court is referring, and the court is acting as a referral judge, not to decide, deliver a judgment. They are deciding that matter to be referred to ADR. It is an excellent provision which we can't see in any part of the world except Singapore and some quite prominent jurisdictions where a lot of say is given for the mediation and other ADR. Interestingly, India, we have, based on the Justice Malimat Committee's report, we have this excellent inclusion, and we have to try it. If a court is going to refer the matter to mediation, what happens? The process is very simple. The matter is being referred, not 1 or 2 cases. It can be 20 cases per day. It will be referred. It will be referred to the court annexed mediation centers. Every district court has a pan-India. And once it's referred, a mediator will be appointed. And that mediator is not a normal mediator. That mediator is a trained mediator under a committee called MCPC, Mediation and Conciliation Project Committee. It is part of the Supreme Court, and that particular committee regularly facilitates and train professionals to become mediators, and from that list, mediators would be appointed and your case would be dealt there. If that mediation is successful, that settlement can be once again referred to the court, and the court would record a settlement decree, and it is once for all, that matter settled and it will be enforceable. If it is not settled, also not an issue, it gets back to the court and the court can continue with the normal process the normal judicial process. This court annexed or court referred mediation can be taken seriously by the litigants. Why? Because it gives an opportunity for disputes which is less complicated, a mid-level value, not much monetary claim involved, and less complex legal issues are there. It is better to be referred. Otherwise, after 5 years or 10 years, depending upon the various levels of appeal, if the matter is finally settled, the outcome might not be a value for the even the successful party. Here, we have to take into consideration what are the advantages and how we are going to deal. Now, for this court annex mediation, we also have a facilitation which has been by way of a bill called Mediation Bill 2021. I think many of you would have already come across it. Now, in India, we are going to have a law for mediation. Till now, we have a law for arbitration conciliation. Now, there is a proposal to have a mediation law. And that mediation law is not only customized to our country, it is like a harmonized system which is being facilitated by a protocol called Singapore Protocol on Mediation. Technically, it is called United Nations Convention on International Settlement Agreements, UNISA. UNICA in the year 2019 was signed by India also during the month of August at Singapore. And now more than 50 or 60 countries have already ratified this particular convention. And India is one country who is on the verge of ratification and trying to bring a law for mediation. Law for mediation, and already there is a law for arbitration conciliation. And we do have a law for effectively dealing with Lok Adalat, that is the Legal Service Authority Act, makes this ADR to now be considered as appropriate dispute resolution. All your disputes, whether it is going to be commercial or construction or maritime or any other nature except so specifically mentioned in some special statute which has to be dealt only by the courts or by the tribunals, let those cases alone goes to those tribunal or the courts. All other issues now, whatever has not been covered under arbitration is now been covered under mediation. Segregate all those as advisors, legal advisors to parties. Place the options available. Give the options which has the benefit of cost, which has the benefit of less intensivity, which has a less possibility of less appeal, which also gives the possibilities of flexible procedure. We, as lawyers, when you're just going to advise the parties or parties when they wanted to opt for or consider which is the best mechanism to resolve the dispute, the expectation of the parties is that they wanted to have their case to be kept confidential. No party would be interested to share everything in public. But the same, that person goes to the court, it is public hearing. There is no confidentiality or privacy in it. Any court proceedings is public. Anyone can watch, anyone can monitor, anyone can also record nowadays. There is no privacy. And if that privacy and confidentiality is not there, then what will happen? The disputing parties would lead to an adversarial situation wherein post resolution of the dispute, even by the courts, by way of a judgment, their relationship would get spoiled. Their cordial relationship, it gets spoiled, particularly if the dispute is commercial in nature. What will happen? We, the beneficiary, a third person, assuming that a person is a supplier of steel, he considered to be a monopoly, and there is a distributor in a particular region, he is considered to be another monopoly. If these two persons enter into and supply a product to us, we'll get the product in a reasonable price. If a dispute comes and their relationship gets spoiled because of going to the courts, what will happen? This monopoly effect would ultimately lie on we people who are the beneficiary or consumers. Try to find a solution. If those two persons, instead of going to the courts, if they go to an ADR process, obviously their relationship might be maintained, the cordial relationship might sustain, leading which they will continue with their relationship post resolution of their dispute through ADR. That is very important. Privacy, confidentiality. Next, the flexible procedure. What is happening in the courts? Lawyers, fine, we are trained to that, and we are also happy effectively enforcing the principles laid down in Civil Procedure Code. We are adhering the each and every provisions of it. No doubt, it is an excellent legislation. Along with that, we are also adopting the Evidence Act. Both works very well when it comes to structuring a dispute resolution process in the court. But for a dispute which is not so quite unique, which is less significant, if we are going to apply these procedures, what will happen? The parties would ultimately wait for a long time to get the matter resolved. It is not because of these stakeholders, it is because of the procedure which we cannot just overcome in a simple manner. It has to be constructively overcome. To constructively overcome this particular aspect of the process which has been laid down, you are going for arbitration. If you go for arbitration, it's very simple. When you get back to the provision, there is one interesting provision in Arbitration Conciliation Act 1996, that is 19. Section 19 says that the arbitral tribunal is not bound by Civil Procedure Code and Indian Evidence Act. That sets. Now, our procedure is flexible. We need not follow a rigid procedure. If we are not going to follow a rigid procedure, then ultimately the resolution of that particular dispute would be made within a reasonable time at a reasonable cost with less procedures. Thirdly, we have a concept called party autonomy. The litigants have the autonomy. In courts, whether we as lawyers or we as litigant has an authority to appoint the judge? No. The appointment of the judge is done by the state. The state has its own mechanism, the procedures of appointing these judges, whether the apex court judge or the higher judiciary or the subordinate judiciary. There is a process. That structured process, we have no role in it. If we want to have a role to manage our dispute effectively, we need to have the power to appoint the judge also. When it comes to arbitration or mediation or conciliation, we have the authority. As parties or parties representative, we can choose the best person for our case. Not only the best person, the right person. Why I'm mentioning is the right person is that a dispute, we can say a dispute, which is on highly on a financial aspect, calculations, and it is all on the accounts part. Many people would be masters in accounts, but assuming that I am coming from a science background, becoming a lawyer, and at some point I am becoming a judge. If as a judge, I am dealing with a dispute which is highly technical, my expertise is not that. My expertise is something different, but still I am a judge. When I'm going to sit, I can be the best person to understand and deliver the judgment, but I won't be the right person to understand because I am lacking the expertise of that particular domain. If I myself have that expertise and if I deliver the judgment or the outcome, then that particular outcome would be so effective, understanding the factual situation of it. That's very important. A dispute is not only has to be dealt totally with law, the facts also has to be kept understood in a clear manner so that the outcome has to be satisfactory, wherein a concept called win-win situation is essential. It is not that always one has to win and another has to lose. Both party has to win. It doesn't mean that both are going to be successful. One might be unsuccessful, but still his satisfaction level would be win-win. He is not going to lose anything. He is still going to maintain the relationship. That is possible when we opt for this particular ADR mechanism, and particularly if the party has the autonomy to choose the judge, whether it's arbitrator or mediator or conciliator. Not only that, the party has a right to choose the procedure, how to be conducted. Very important. What is the procedure? CPC is not applicable, then the procedure is entirely laid down by the parties themselves. They can complete the arbitration or mediation or conciliation within a day, within an hour, or it can be completed within the time what has been prescribed by the law. Arbitration, there's a timeline. Now, the 1996 Act got amended in 2015, 19, and 21, and it is well settled that an arbitration has to be completed within 12 months after the pleadings are exchanged by the parties. This time frame, we can't see it in the courts. Next important thing, why we are going for ADR, and particularly the very objective of this webinar is not only to bring out the what is the scope and development. LJRF also has an idea to bring 30 interesting trainers from this. The participants are likely to be also brought in as trainer so that to convey the entire message about ADR and how it works, not only in a theoretical part, in a practical way, to the end users and beneficiaries. Here, the fourth interesting part in when opting for ADR is interestingly a component called efficacy. Efficacy in a process. How it is efficacious? It is only efficacious because that process is being facilitated by a domain expert. If it is a family dispute, we cannot take it to arbitration. There is a highly doctrine called arbitrability and non-arbitrability that I'm not going to touch here. But when it comes to scope of applicability of a particular family dispute, we can take it to mediation. In mediation, who will be the best person to mediate? Whether we lawyers, we might have the expertise, but still a female lawyer is better. She might be the best person to understand the perspective of various issues in a family life. Not only that, the best person might also be a social worker, because a family constitute, multiple family constitute the society, and the society wants to be harmonious. The family has to be constructive. The person who is considered to be a social worker might be a better person. It doesn't mean that he or she is the best person, might be the better person. If the dispute is on maritime, who would be the best person? A master mariner, not we people. Here, the opportunity is given to the parties to choose that person as the judge. The technical experts can be placed in as a judge to deal with such disputes. All these, along with one interesting aspect which facilitates why we are going for ADR, is all about enforcement. We are having a process totally not connected with the courts. And there is a general say is that a concept called NSJS, I think many of you would have already come across, which is called non-state justice system. The state has no say. The state justice delivery system also has no say. And this NSJ is considered to be violating human rights. But still, in some region, if you go to a coastal part, I'm not sure about the multiple coastal part of Kerala. If we are assuming that we are going to the southern part of Kerala, particularly around Kovalam or Trivandrum, there will be a lot of fishing hamlets. The fishing hamlets, the people also do have some disputes. Whether those disputes are being taken to the courts or ADR, no. Most of the cases are being dealt among them, and that process might be considered as a NSJS, which is against the human rights, against the justice delivery system. But still, it is acceptable by that community because it is well suited. Not only that, ultimately it is enforced also. The enforcement process might be different, but still it is acceptable and enforceable. We can't accept that. As a civilized society, having a constitution, having declared safeguarding the human rights, we can't accept that. But we can still accept ADR. Why? Because this ADR outcome also is acceptable. In technical language, recognized. Recognition is there, as well as it can be enforced. If a process gives an outcome which is recognized and enforced, then ultimately that process, even though it's happening outside the court, even though not following CPC, even though having a person who is not a qualified judge, the outcome, if it has been enforced, it will be acceptable. And it is not only we accepting, now the law also is clearly giving the mandate that this has to be accepted. The interesting part is that post award, an award is given. What is the opportunity? Whether we have a multiple layer of appeal, we do have, but the appeal is not termed as an appeal. They call it as a setting aside process. And the mediation bill also, they are given an opportunity to set aside a settlement agreement if there is a coercion used to go for that particular settlement. These challenge are on only procedural grounds, not on highly on the legal part. This legal part is well taken care, and the appeal also has to be, the application for setting aside also has to be concluded within a reasonable short time. If you are going to get the recognition and enforcement, that is very important, is quite evident in the ADR process. All fit together, now we have a law. We have law for arbitration, we have a law for conciliation, we are going to have a law for mediation, we have a law for Lokadalat. With all these constructive ADR mechanisms, which has its... anyway, I wanted to say that now for us to and the development, what's happening. Am I audible now? Okay, fine.
Yes, sir, you're audible.
Yes, sir. The thing is that we have to take all as a serious profession, because there is a fine development which is happening in arbitration or mediation, is that the law is going to create two important councils. One, Arbitration Council of India, and the Mediation Council of India. These two councils are based of the arbitration law 2021 and 2019 and 21 amendment, and the mediation bill are going to create a platform called, or a profession called, arbitrator and mediator. Just have a look on the ACI and MCI of this legislation, and they are going to facilitate professionals to be part of taking the role. This role is not only confined with lawyers like us, this role also can be facilitated by any other professionals like chartered accountants, company secretaries, cost accountants. All professionals can also be involved and constructively deal with arbitration in a professional manner. As of now, what we have BCI, Bar Council of India recognized advocates. People who are getting enrolled through the bar councils of the respective states are eligible to practice as advocate. Likewise, the proposal already published, the base work has started. Like the ACI is in the final stage of constituting, and once ACI is constituted, we all are going to be accredited as arbitrators, depending upon your interest and experience, and we are also going to be accredited as mediators, depending upon our experience and post-qualification opportunities, what you're getting involved in these ADRs. Take this, whether you're going to be future trainers or whether you're going to be mediators or arbitrators, this is going to be a great opportunity for you to facilitate the effective dispute resolution in our country. And additionally, we, LJRF, along with KFCRI, an institution called Kovise Foundation Conflict Resolution International, are going to take this in a large scale, reaching the grassroots level of, possibly to start with the grassroots level in Kerala, in the major districts. Each and every individual citizens have to know about what is ADR and what is the opportunity. And this opportunity is not only facilitated by us, by our institution. It is a facilitation which has been already advocated by our father of nation when he was practicing law in South Africa. Having said that, this is the right time for us to get in ADR, and if you can constructively get involved in ADR, then we can also deliver the justice delivery system in a proper way for non-essential, commercial, family disputes. Thank you. Thank you for the opportunity about the scope as well as the development of ADR in our country.